Okay, this is Tozen Daigaku. Sorry for the technical difficulties and the delay. Zoom froze and it knocked us off. For some reason, it knocked us off live stream and it took us a while to get back. So sorry for making you waiting. I'm Louis Carlet. I'm the Senior Organizer and Chief Finance Officer of Tozen Union. And in today's edition of Tozen Daigaku, we will be covering labor law principles and precedents.
Okay, hello, I'm sorry to be late, and I'm Hifumi Okunuki, and Tozen Union President. And I will tell you three interesting labor law cases in Japan. And later I will I'll speak in Japanese, and Carlet interpret from Japanese to English.
Turn down the sound. Okay, thank you very much. Okay, so Oren, can we have the first slide, please?
Hey.
Okay, so okay. That's not the first slide. So that's the seventh. Yeah, the first one is the labor law principles and precedents.
It should be this one, forward to 100.
Put it. Oh, sorry. YouTube. Okay, sorry, that was the right one. Okay, so labor law principles and precedents. Okay, in Japanese it's called forthright to hanrei. Okay, can we go to the next slide, please? Okay, so the first, there's 7 that we're going to cover today. Okay, next slide.
Yeah, I have. It's just a bit.
Okay, first one is a very, very important. Hold on, can you turn on? Yeah. The first one is Tozen. Kumiai no Tozen. So Tozen is a really difficult word. It took me many, many years to understand the concept of Tozen. It's often translated as solidarity or unity, but it's a really important thing for the legitimacy of union activities. All union activities in Japan are based on solidarity. Okay, and the idea behind what oh, sorry, can you go to the next one?
Yep. Okay, yeah, it's
yeah, sorry, we're not
that's slow. So it's fine on here, just slow on that.
But she's looking at YouTube and she can still see
YouTube's slower.
Oh, okay.
The audio and everything's on time.
So I should wait until it changes, right?
No, you can carry on.
Okay, but are they looking at the wrong slide?
No, because what we've got here.
Oh, now it changed. Now it changed. Okay.
Yeah.
Yeah. So this is Tozen, Kumiai no Tozen. Like I said, solidarity makes all our union activities legitimate. Okay, so whether you're striking, doing collective bargaining, petitioning, or doing a protest or negotiating, all these things are based on the right to solidarity. So what the law expects of unions is that they act as a unity. Okay, so this is something even to the point of military discipline. That's why I put the word military discipline in there. Tozen is the idea of complete control and unity of action. So anything one member does, the entire union is doing it. So actually, it's not individuals who are striking. Legally, when someone strikes, the entire union is striking. And that's the concept of Tozen. So anything that a member does, the entire union is responsible. And that's why it's really, really important to be disciplined when we do strikes or other activities. Okay. So that's something that please keep in mind. So if there's a problem with Tozen, like if one member is kind of going off on his or her own, it's very important that we really get together and make sure we have the discipline and the unity of action, and that we communicate with each other to make sure that we have that. That's another reason why, like in collective bargaining, you can't just say your opinion about it. Like when members democratically choose their policy or their demands or their goals, once they're decided, all members must fall in line. They can't publicly contradict the demands or the policies of the union. And that's also why members cannot ever talk to management about the union or union policy or union demands outside of collective bargaining. This is very important. Any time an individual member talks to management about the union or the demands or negotiates those conditions, it violates Tozen. It violates this solidarity, unity of action, and unity of purpose. Okay, I'd like to go to the next slide.
Next slide is done. Don't
Okay.
wait for YouTube. Don't wait for YouTube.
Okay. The next slide is, the next hori is goりてき. Now this word really just means reasonable, rational, logical, or sensible. Goりてきis a thing you find all the time in the law, in verdicts, in briefs, legal briefs, and it's something that is really crucial to understand. What the law says is, in a very simple, basic, fundamental sense, how it's interpreted and how normal human life and society are interpreted must be based on what is considered goりてき. Now, of course, that's kind of a subjective thing, and that's where the judge's subjectivity plays a role. So you can't make an argument that is kind of like really out there or lacks a kind of reasonable, rational stuff. It's not just rational and logical, it has to be reasonable as well. And so this is something that often I want to say something that's really like, I take a principle and I take it to an extreme and kind of like use like a really pedantic type of logic to kind of prove something. But at the end of the day, it has to still be in the normal realm of what is reasonable. And that's the concept of goりてき. Okay. Yeah, because the law cannot cover every single situation in human life or society. And that's where the judge makes the decision based on what is reasonable. Okay, this person says, like the defendants are saying this and the plaintiffs are saying this. What is a reasonable interpretation of what is the reality and how it should be interpreted in relation to the law? Okay, next slide, please. Okay, next hori is 正当な組合活動. 正当な is the key word here, and it means legitimate. And so the question is, what is a legitimate union action? And if it's not legitimate, it's not legal. So it's almost synonymous with legal here. So what is a legitimate union action? This is a crucial question for, like, is your strike legal? Is your strike legitimate? And there are many things to look at. One is what I said about goりてき. Another is what is social norms. And there's certain things like a strike, like if you strike without doing collective bargaining, it's not a legitimate union action. If you strike without trying to resolve it through other means, it's not a legitimate action. If you use any violence or threat of violence, it is definitely not a legitimate union action. So the idea of what is a legitimate strike or protest, first, you use collective bargaining. The union uses collective bargaining with management to try to resolve the demands through negotiations. If that doesn't work, you can strike or protest in order to realize those demands that you couldn't resolve through negotiations. You can't strike or protest to realize other demands or demands that have not been negotiated or new demands. You cannot strike in order, what's called a sympathy strike. You can't strike in solidarity with another union, unfortunately. You can only strike to realize demands that you've tried to resolve through the negotiations. Also, you cannot strike or protest for political reasons. So all these are many factors that makes a union action legitimate or not. And it's always important before the union strikes
or does any kind of that kind of action, that we make sure it's completely legitimate. Another thing that would not be legitimate is if the purpose is more to hurt the company than it is to realize the demands. So these are some of the things that take away the legitimacy and could make your strike illegal. Okay, let's go to the next slide. Thank you. So the fourth hori is, actually there's two here, but it's kind of the same thing. Taishoku kannshou and taishoku no jiyu. Okay, taishoku kannshou is a very Japanese concept. And what this is pressuring someone to resign from their employment. And it's, in Japan, it's a thing. It's different from dismissal, different from resigning. So like in Japan, if you have an employment relationship, that employment relationship continues unless the worker resigns or the employer fires that worker. Now, this though, taishoku kannshou, is neither of the two. It's pressuring someone to resign without firing them. And it could be legitimate. It could be just harassment, but if there are legitimate reasons for that to fire the person, then pressuring someone to resign is a legitimate action. Now, the reason, why do employers do this rather than fire somebody? Well, because if they fire someone, they are under responsibility, they have the responsibility to justify that dismissal. It's not easy to dismiss a permanent employee in Japan. And we'll get to that in the next slide, but not yet. So what they do is they pressure you to resign, because if you resign, then you cannot challenge that termination of the contract later. So it's a kind of a escape clause for management. They would much rather you resign than have to fire you. Because again, if they fire you, then they're going to be responsible for that. And this is all based on the freedom of workers to resign their work. Slavery is illegal. You can resign from your employment. Now, the civil code says you have to give 2 weeks notice, but at the end of the day, depending on the circumstances, you have the freedom to walk out of your job. Now, theoretically, your employer could possibly sue you for not giving enough notice if it causes financial damage and if they can prove that. But even then, you have the freedom to walk out. And in most cases, the employer could not win if they tried to sue you for giving lack of notice. And in reality, I've never seen it. I'm sure there are cases, but I have never, in hundreds of cases of sudden resignations, I've never seen an employer actually go to court to sue, because they have very, very little chance of winning anything, to prove that your sudden departure caused specific amount of financial damages. So at the end of the day, you have the right to resign. If you can, give as much notice as possible, but if you can't and you have to leave, then you have the right to leave. And you have the right to resist taishoku kannshou. You can say no. You don't have to sign anything. Management might say, here, you sign this. You don't have to sign it. If you don't want to resign, definitely do not sign it, because once you sign it, that's it. And you can just stay there and force them to officially dismiss you. And that dismissal you can fight. And there's lots of ways you can fight. And if you're a union member and you have a strong union there are ways we can fight. Like right now at Bagunto, we're fighting for one of our members because they terminated his employment. So, okay, let's go to the next slide. Okay. Number 5. Okay. I thought I switched this around. Okay. Number 5. This is kizen to suru. Kizen to suru. I kind of put them in the wrong order. Kizen to suru is a really difficult expression in Japanese to explain. And this, I explained it as like professional, unperturbed, forthright, earnest, no nonsense, unashamed, level-headed, righteous, sober, straightforward, unassailable. This is really difficult to explain, but this also underpins the legitimate union action. It's important that in the middle of like a demonstration, it doesn't look like you're just fooling around, that doesn't look like you're casual or sarcastic. Sarcasm is really bad for kizen to suru. And it's something that you show that you're professional, unashamed of what you're doing. When you're striking, you're not ashamed of it. You don't feel guilty. You don't feel apologetic. You do it because you're just exercising your right in order to win the demand. And it's just straightforward. Not there's no like defensiveness. So this is something that I really try to instill in our members, the need to be kizen to suru about something. In other words, like let's say you're in a demonstration, the cops show up because management called the cops. Don't run away, don't look guilty, keep doing what you're doing. Of course, talk to the cops, but keep doing what you're doing, and you cannot show the slightest embarrassment about it. And this is really important in Japanese society and in the context of a legitimate labor action. Okay, next slide. Number 6. Okay, this ties in with the one we did about taishoku kannshou. And again, I put them in the wrong order. So this is abuse of the right to dismiss. Kaiko ken ranyo. Okay, kaiko ken is the right to dismiss. And unfortunately, employers have a right to dismiss. But ranyo means abuse of that right. And so in other words, they have the right to dismiss, but there must be legitimate reasons. And Japan is famous for it being very difficult to fire a permanent employee. So they can't just fire you because they don't like you. They can't fire you because they don't like your face. They can't fire you because they decided they want to cut personnel costs. They have to have a legitimate reason. So when can they fire you? Okay, so there are several, first of all, there's several types of dismissals. What the 3 main types are tsujo kaiko, that's an ordinary dismissal. There's seiri kaiko, that's a downsizing dismissal or what's often called layoffs. And the third is chokai kaiko, which is translated as disciplinary dismissal. Now, let's do the ordinary dismissal last. The chokai kaiko, disciplinary dismissal, is when you stole money from the company, okay? An employer could then do a disciplinary dismissal. And this is worse than a dismissal because they don't need to pay like severance that you might have built up for a long time. They don't need to, there's a way they can get out of paying even 1 month's notice that they usually have to pay. But it's not just that if you stole money, but let's say you were violent at the workplace or you sexually harassed some of the coworkers. In these cases, it's possible that they could do a legitimate disciplinary dismissal. Okay, the next dismissal I'll talk about is, and by the one more time, the disciplinary dismissal is called chokai kaiko. The next dismissal is seiri kaiko, downsizing or layoffs. Now, seiri kaiko is possible, but again, it can't be done in a cavalier manner, and it can't be done unless there's really good reason. And there's 4 conditions that more or less should all be met. Let me run through those 4 conditions. One is the company has to be in serious financial difficulty, like serious, like the survival of the company might be at stake. The second one is they have to explain to the workers and the unions why there's a need to dismiss people to save the company. Third, they must make an effort to avoid dismissals. In other words, there's ways to cut costs without dismissing your employees, and you must try those things. And there are many ways. Traditionally in Japan, there's voluntary retirement program, or what's called soki kibo taishoku or kibo soki kibo taishoku. So basically what they do is they offer you money to resign voluntarily. And another possibility is cutting the wages a little bit. So they must do something before they turn to actual layoffs to avoid layoffs, okay? And then the final condition that must be met is that they have to choose who to lay off in a rational or goりてき way. They can't just choose who they want based on who they like and don't like. Or there has to be some reason. So often the reason is that they're either more expensive or less senior, or there's all kinds of reasons, but it has to be goりてき reasons about who to lay off and who not to lay off. So it's jinsen no goりせい. So again, there's that goりてき coming up again. So okay, and then let's go to tsujo kaiko, ordinary dismissal. So if neither of the other two apply, what is an ordinary dismissal? So a lot of people think that if you don't perform well, the employer can fire you. That's not true. Your performance has to be extremely bad to justify a firing. And it has to be not just extremely bad, it has to be so bad and no hope of improvement. And so what a lot of employers do, especially in high income positions, is that they do what's called a PIP, a performance improvement program. And it sounds nice, like, oh, they're going to improve the performance of their employees. That's so nice. Actually, this is just a step towards firing someone. What they want to do is they give you an impossible set of tasks, and under the guise of performance improvement. And then when you fail, they use that as justification that, oh, there's no hope. This employee is so bad and couldn't improve, his performance. So we had to let him go. So it's just creating a paper trail. And you'll find that these PIPs, performance improvement programs or plans, are often simply impossible to achieve. And so when you get a PIP, know that 99% of the time your employer plans to fire you. And there's ways that we can deal with that. Okay, so that's one reason an ordinary dismissal might be justified. Now there's others too. Others are, let's say you're late all the time, or you're absent without leave, without good reason. Any kind of like serious attendance issues, Japan is pretty strict about punctuality, at least at the start of work. They're not good about punctuality at the end of work, because lots of unpaid overtime and blah, blah. But about the start of work, if you're always late and they warn you and you're still late, that could be justification for an ordinary dismissal. Okay, so if you're late once or twice in a year, that's not enough. But if you're routinely late and there's no improvement, they could be justified in firing you. Now, again, if you're a permanent employee, you're pretty solid. As long as you show up on time, you're pretty solid. It's not that easy. Okay, so that's attendance issues is definitely a reason that they can fire you. Another justification for ordinary dismissal that we're seeing lately is closure of a department or division, or the work that they had for you disappears. And this is something we're fighting in court, but let's say they just decide that they have some good reason to close a department. And this is what we're seeing at Simul, where Simul closed the department and fired everyone in that department. Actually, in that case, it was a non-renewal, but and they're saying, look, we had to close the department. There's no work for them. What are we going to do? So this is something that employers are trying to justify, and we'll see in court how far that goes. It might, some courts might accept that as a reason. So these are some of the reasons that you'll get for an ordinary dismissal. Barring all those reasons, they can't fire you. They can't fire you because your performance is mediocre. They can't fire you. This is another important thing is your employer cannot fire you even if you're the worst performer in the workplace. This is really crucial. There's a thing called sotairon, which is basically relativity. Relativity in the workplace means you could be the worst worker in your workplace and still great, because what if all the workers are great? So the courts do not accept simply comparing your performance. Let's say you're a salesperson and you sell less than anyone else, but you all sell a lot. The fact that you sell less than the others doesn't mean that you're a bad performer, let alone bad enough to justify firing. So there has to be really serious problems with your performance, and there has to be some attempt to try to improve it. Employer can't just the first time you screw up, fire you. They must go through some process to try to either train you or improve your performance. And then if there's still no apparent improvement, and let's say they're justified in saying, oh, there's no hope for this person, then they can fire you. Okay, so I think that, oh, one more thing I almost forgot. Insubordination. When you're at work, it's a dictatorship. Your boss is your dictator. The boss, she gives you work orders, you comply with the work orders. If they're a legitimate work order, you must follow. Or if you routinely disobey orders, that can be justification for firing you. Now, it has to be legitimate work order. They can't tell you, okay, you know, I want to go to dinner with you or come to the company party after work. It has to be related to work and it has to be justifiable. It can't be anything personal related. It can't be something that's unrelated to your job. But if it's a legitimate work order related to your job, you must comply. And if you don't, and if you routinely don't, that can be justification for dismissal. Other than all those reasons, you're totally fine. Okay, next slide, please. Now, all these principles are based on one assumption about you. That is that you're an employee. But are you an employee? Many people, believe it or not, don't even know if they're an employee or not because it's a kind of a legally obscure thing. And unless you know about labor law, you might not even know. The employee relationship, it's important to ask yourself, do you have an employee relationship? Does your contract say employment contract or labor contract? Do you get wages? There's many things that determine whether you are an employer or not. What's not an employee is, are you freelance or what's called gyomu itaku? And this is like a independent services provider, or often called independent contractor. Gyomu itaku, if you're in that relationship, it's not employee status. So you don't have all those protections. Okay, so it's really important to make sure you understand whether or not you're an employee. Now, just because your contract says gyomu itaku or outsourcing or freelance or independent service providers doesn't mean necessarily that you are. The court will look at what the reality of the situation is. And from now, I'm going to talk about different things that determine whether you are indeed an employee or not. Okay, but before I go there, and that will be another slide, by the way. Before I go there, employee status, unfortunately, is defined differently for different labor laws. And this is something really frustrating and confusing. So if we're talking about shakai hoken health and pension law, that's one definition of employee. If we're talking about unemployment insurance law, that's another definition. If we're talking about trade union law, that's yet another. And then if we're talking about Labor Standards Act, that's yet another. So what I'd like to talk about is that the broadest definition of what an employee or a worker is under trade union law, which is good for unions. So even if you're gyomu itaku under other laws, as long as you are roudosha, that's the word employee is roudosha. As long as you're a roudosha under trade union law, you have the rights to union activities, you have the right to striking, you have the right to all those things. And this is something that we're fighting at GABA, because GABA says that all their teachers are gyomu itaku, or they're individual service providers. So GABA claims that basically the teachers are their own little businesses. And you have this huge company, GABA, negotiating contracts with one teacher each. And of course, the reality is GABA decides everything and the teachers are in effect employees. And that is what the union has been asserting, that despite what GABA says, they're in fact employees. And we'll talk on the next slide about how to determine that. And at GABA, we actually sued in the Labor Commission to assert our right to strike. And GABA claims we don't have the right to strike. We won the Tokyo Labor Commission, and now we're moving towards a verdict in the Central Labor Commission, which is for all of Japan. Now I'd like to go to the next slide to go more in depth about this. Okay, sorry, this slide has a lot of information in it. So these are 8 items that you want. This is a checklist that the Ministry of Health, Labor, Welfare set up for us to determine, are you, in other words, regardless of what your contract says, go through this checklist to ask yourself, are you an employee or not? I mean, if your contract says employee and you get wages and you're all that, you're probably okay. But take a look at these 8 questions. And this is something for GABA instructors as well. Okay, number 1, you have the, okay, so yes to these questions mean that you are a rodosha. So number 1 is you have no freedom to say no when presented with work. If you're an employee and your boss says, okay, here's a project I want you to do for next week, or write this report by tomorrow, something like that. That's, if you're an employee, you can't say no. That's a legitimate work order, just like we talked about. So you can't really say no without, you know, threatening your employment. Of course, you're a free human being and you can resign or whatever, but as long as you're employed, you must follow legitimate work orders. If you are truly freelance or services provider, remember you're a different business. So you can choose what jobs to take or not take, okay? This is just one of the many of the 8 items in the checklist. So are you free to say no? If you're an employee, you're not free. If you're not free, then even if your employer claims you're gyomitaka, it might be that you're actually rodosha. Number 2, you must follow orders. This follows right on from the last thing. If you're actually a separate business, like a services provider, and you're just providing services, you don't have a boss, you have a business partner. So GABA instructors, ask yourself, is that middle manager, is that your business, is GABA your business partner or your boss? If it's your business partner, then maybe you are gyomitaka, and if it's your boss, then you're probably rodosha. Okay, number 3. Number 3 is the company or your boss sets the work hours. When do work hours begin? When do work hours end? And also your workplace. If you're gyomitaka and you're a separate independent services provider, the other company tasks you with an order and says, we want this done, and we'll pay you this amount for this project or whatever. You can decide where to do it, when to do it, because you're providing a service, not specific hours. Now again, all these things by themselves are not enough, but all these things together begin to create a picture of whether you're rodosha or gyomitaka. So if the other company decides when you start work, when you end work, where you work, all those things, it's more likely that you're a rodosha employee and not a business partner like a gyomitaka. Number 4, you cannot replace yourself. Okay, let's say you're a teacher at Berlitz and tomorrow you have a class, but you have something you really want to do, or you have somewhere you have to go, maybe another job or something like that. Can you say, you know, tomorrow I can't go, so I'm going to send Oren to teach in my stead? Obviously, you can't do that. Berlitz would not allow that because it's an employee relationship. Berlitz admits that it's an employee relationship, so you cannot do that. You cannot simply send somebody else in your stead. If you're gyomitaka, if you're a services provider, you're providing a service, not the labor of a particular human being. So then I would be able to send Oren to do the job I intended to do myself because I'm a little business and I'm providing services. So the other company cannot tell me who I should send, whether it's myself or Oren or Hifumi. I can decide. So that's another really crucial feature that the Ministry of Health, Labor, Welfare sets on this checklist. Okay, the next, number 5 is a little more difficult to understand. You get paid for your labor, not a service or a project. Now, companies that claim you're in a gyomitaka relationship, of course, they're not going to say we're paying for your labor. They're going to say we're paying for your service. Many employers know the language they have to use. But again, you have to ask the question, are they really paying me for my labor or are they paying for this service? And this ties into all the other items of the checklist too. So this is a key concept about Roma Taisho state, right? Okay, because both are remuneration. One is wages for labor and the other is remuneration for a service or pay for a service. Okay, and some examples that show that you are getting paid for labor is, are you paid by the hour? Are you paid overtime? Are you deducted when you're not there? All these things fit more with wages to an employee than it does to paying a service fee to a service provider. Okay. Number 6. Yeah, and let me give you an example for service providers. So let's say you want to renovate your kitchen, okay? When you renovate your kitchen, you pay, let's say, a company, even if it's an individual proprietor, and they come in, they do the work. You don't say, I don't want that guy, I want that guy over there. You don't say that. It'd be really weird and inappropriate to say that because they're responsible for getting it done the way you want. Okay, so they can send whoever they want, and you're paying for the service, not for the labor of those people. Okay, so that's how this all fits in. Yeah, and number 6, this is like, is the worker part of their own? Is the worker like, let's say I ask Oren I pay Oren for something. Now, is Oren acting as Oren or is he acting as my company? Let's say I have a company, like a trucking company like that. Is he acting independent as Oren's business, or is he acting as part of the company, right? So in that sense, like, does Oren use his own truck or my company truck? Does he use his own PC or my company PC? All these things decide if he's using the company PC, the company trucks, that makes it more like he's part of the company, my company, not part of his own business. But if he's using his own stuff, his own truck, his own equipment, then it's more likely that he is a services provider. Going back to my kitchen renovation, it's very unlikely that those people are going to use the tools that are in my house for the kitchen renovation. They're going to bring their own tools because they are service providers, even if it's one person. He or she is going to bring their own tools, their own equipment, and on their own, they're going to do it their own way, their own method. If I'm not going to tell them, well, when you renovate, I want you to, I don't even know the words to use, but let's say I did, and I want you to, sand down this wood part in this particular way. No way. They're going to do it and produce the product that I want at the end. Okay. Number 7, this is, are you dedicated to the company? Can you, like, especially if you're full-time, employers expect you kind of to prioritize the company over other work, over other things. I mean, this is a really Japanese thing as well. If you're a Gyomu Itaku services provider, there's no need to be exclusive with one business partner. And this is something GABA has always asserted, that the teachers are free to teach anywhere else, and we don't ask for any particular devotion to our company. Okay, so that's something. And again, this is, these are all like not so easy to determine clearly, but. And then there's number 8 is other factors. Are there rules, regulations like dress codes? Do they withhold your taxes? Is there a fixed pay? Was there an extensive interview and hiring process, just like they do with employees? In other words, if you're asking a service providers, you don't really have interviews per se. You might shop around, but there's a difference between shopping around and interviewing many candidates. So that's something to look at. Also, if there are benefits. So all these things together determine whether you are an employee or not an employee. And of course, courts have to determine that. Now, like I said, the base is trade union law. Now, what you really want is to be a労働者 based on Labor Standards Act, because that gives you the most protections from the law. And that's a little bit harder than it is to be a 労働者 under trade union law. So I think that covers that. Okay, and from here, next slide, please. So I'm going to turn it over to Tozen Union Executive President, Hifumi Okunuki, and go from there.
それでは通訳お願いします。
Okay, so please interpret for me.
はい。今、7つの法理についてルイスからお話がありましたけれども、それに関わる3つの判例を紹介します。
So now Lewis just explained 7 legal principles. Now I'm going to introduce to you 3 court cases that are related to or incorporate those legal principles.
次のスライドにお願いします。はい。まずじゃあ1つ目の判例ですけれども、これは労働法の中ではめちゃくちゃ有名です。
This is an extremely famous case in labor law.
で、さっき、ルイスが7つの法律の中に、すごく重要な法律ですね、解雇権濫用法律っていうのを紹介しました。
And this case touches upon one of the 7 legal principles that Lewis spoke about, 解雇権濫用法理, or the legal principle of abuse of the right to dismiss.
はい。で、解雇権濫用法理を語るときに、必ず引用される判例、これが今からお話しする高知放送事件です。
Whenever scholars discuss abuse of the right to dismiss, almost without exception, they refer to this court case, and it's the Kochi Broadcasting Company case.
はい。この判例は1977年に出されているので、かなり古い判例です。
Yeah, and this is an old court case. The verdict came out in 1977.
なので今これ聞いてる人が30代未満の人だったらすごく時代を感じるのではないかと思います。
40 seconds. So if you're under 30, this is probably seems like the distant past for you. And then I said, maybe even if you're under 40.
はい。じゃあ、事案の概要を説明します。
Okay, so let me explain a brief outline of it.
はい。原告は、高知放送事件というラジオ局で、雇われているアナウンサーでした。
Okay, the plaintiff was a radio talk show host.
で、この原告はテレビの
news or talk show?
ニュースです、
ね。Yeah, I'm sorry, not talk show host, I'm sorry. A news announcer. He was a news announcer on the radio, yeah.
はい、そうですね。で、テレビではなくてラジオのアナウンサーですね。
Yeah, and this is radio, not TV.
はい。で、この原告は朝のニュースを担当していました。
And he was in charge of announcing the morning news on the radio.
はい。で、これライブ放送でした。
And the news program was live.
で、この原告はもう20年ぐらい働いている、結構ベテランのアナウンサーでした。
He was a veteran announcer with more than 2 decades in this job.
その原告がこの朝の生中継のニュースの時に寝坊してしまったんですね。
Yeah, but this announcer overslept the morning program.
で、しかもですね、その時に担当しているニュースを放送することができなかったんですね。
And because of that, they were unable to show the morning news program.
で、ニュース自体はもともと5分ぐらいの短いニュースでした。
It was a 5-minute news update.
なので、その時は仕方がないので、なんかクラシック音楽かなんかを流してごまかしたそうです。
And so the radio station, they had no choice, but they played classical music during those 5 minutes instead.
で、彼すごく反省をしたんですが、
He felt really bad about it and
まあ
and showed remorse.
その後2週間後にまた同じ寝坊をしてしまいました。
However, 2 weeks later, he overslept again.
で、やはりそれも中継、朝の生中継のニュースだったので、結局穴を開けてしまったということなんですね。
And again, they had a gap because it was another morning news program that he overslept, and so they had another gap.
で、そこで使用者は原告に対して、2回生中継のニュースを、飛ばしてしまったということで、解雇通告を出しました。
So the employer dismissed him because he had overslept 2 live news programs.
で、さっきルイスが解雇について、説明したときに普通解雇と懲戒解雇があると説明しましたよね。
So Lewis just explained that there is ordinary dismissal and disciplinary dismissal.
で、使用者はこの原告が2回生中継のラジオ番組を飛ばしてしまったというのは、本来ならば懲戒解雇に該当すると言いました。
So the employer said that the employer could have actually notified him of a disciplinary dismissal because he had twice overslept a live program.
そのぐらいですね、そのアナウンサーとしては重大なミスを犯してしまったという会社の認識だったんですね。
Because the company considered that it was too grave an error as a radio announcer.
ところがですね、使用者側は勤続20年の、それまで真面目に働いてきた原告に対して、懲戒解雇っていうのは、かわいそうだから、こちらはですね、温情をかけて普通解雇にしてあげるというふうに言いました。
And the company said that they decided to show mercy and magnanimously gave him only an ordinary dismissal in light of his 2 decades of working really hard and seriously.
はい、それでですね、原告は結局普通解雇をされてしまったんですけれども、原告はですね、この2回の寝坊によるその番組を飛ばしたということで、普通解雇されるというのも、これもやはりちょっと過酷すぎるのではないかということで、解雇無効を訴えたという、そういうケースになります。
But the plaintiff thought that even the ordinary dismissal was too severe, and so he sued in court to overturn the dismissal.
はい、そこでですね、これ聞いてらっしゃる皆さんは、この普通解雇っていうのは、ひどすぎると思いますか？それともこれは正当だと思いますか？
So I'd like to ask those watching now, do you think that such a dismissal is too much, going too far, or do you think it's just about right?
はい。で、これさっきルイスの解説の中で、解雇をめぐってはですね、その合理的であるかということ、そして社会的相当性があるかという、その2つにね、照らし合わせて判断するという説明があったと思います。
I think Lewis explained that things have to be 合理的 or logical, reasonable, and also be, based on social norms. That has to be sufficient under social norms in order to justify dismissal.
はい。では、結果をお伝えします。
Okay, so let me tell you the verdict.
1977年最高裁はですね、
The Supreme Court in 1977
はい、この解雇は過酷すぎると言ってこの解雇を無効にしました。
ruled that the dismissal was too extreme, and they determined that the dismissal was invalid. They invalidated the dismissal.
はい、そうなんですね。で、もう少し詳しくじゃあ最高裁の判詞を説明します。
So let me explain how the Supreme Court looked at the case.
はい、いくつか理由を挙げていますけれども、まずはですね、
They cited several reasons.
まず この2回生放送を飛ばしたっていうことは、この会社、高知放送の信用を著しく失墜させるものだっていうことは裁判所も言っています。
実際そうした。Okay. Yeah, the Supreme Court recognized that it seriously harmed the credibility of the radio station because two shows were canceled.
はい。しかしながら、まずこの事故というのは、原告が故意、悪意を持って飛ばしたわけではないということですね。
But the announcer did not intentionally hurt the case like that.
で、さらにですね、これはちょっとなんて言うんでしょう、比較考慮の話になるんですが、実はこの原告と一緒にファックス担当者っていう社員がファックスの担当者っていう職名の労働従業員が、オフィスに待機しました。
Also, there was actually another employee who was in charge of faxes, and that employee, they were in the office at the time.
で、実はですね、このあれですね、朝の生放送をするために、この原告っていうのは会社で寝てたんです。前日ね。
Also, it's important to understand that the plaintiff overslept at the radio station.
そう。で、その時に一応寝坊防止のために、そのファックス担当者の人が、もしその原告が寝坊している時に起こす役として、ファックス担当者もオフィスにいたんですね。
And the employee who was in charge of fax was also in charge of waking the announcer up in time for the show.
でところがですね、このファックス担当者も2回とも自分も寝過ごしてたんですね。
However, the employee in charge of the faxes also overslept both of these cases.
で、それでですね、さっき比較考慮って言ったのは、ファックス担当者も2回とも寝過ごしていたにもかかわらず、解雇したのが原告だけだったっていうところも、バランスを欠くっていうのが一つの理由ですね。
So the Supreme Court thought that the company's firing of only the announcer and not the employee in charge of the fax showed a lack of balance in dealing with employees, balance, fairness, and that sort of thing.
で、2つ目の理由としては、確かに重大なミスではあるけれども、その放送自体は5分ぐらいのニュースなので、それほど長時間ではないということも言っています。
The Supreme Court also noted that the show was only 5 minutes, so even though it was canceled, it wasn't like a long period of time that was canceled.
そしてですね、あと原告はさっき言ったように20年ぐらい働いていて、これまでそういったミスを犯したことはなかったっていうことですね。
And also, the court noted that during the 20 years of his employment, the announcer had made no other mistakes.
で、あとはこれまでその高知放送の中でそういった放送上のミスを犯した人を解雇したことがなかったっていうこと。
Also, the court noted that they had not 何のミスで？
そういう放送事故。
Okay. Also, the court noticed that the radio station had not fired anyone else for some kind of accident related to broadcasting the show.
で、こういったことを総合的に勘案したときに、今回のこの解雇という措置は、合理性がなく、社会的に相当なものとして認めることはできないというふうに結論付けました。
So the Supreme Court looked at everything all together, like a comprehensive view, 総合的勘案, and just determined that the court could not accept the argument that there was sufficient grounds for firing the announcer.
はい、これがこの高知放送事件という事件になります。ですね、解雇権濫用法理というのは、この高知放送の判決が出たときには、法律の中には盛り込まれていませんでした。
At the time that this verdict came out, these principles were not in the law yet, not written in the law. I'm sorry, the principle of abuse of the right to dismiss were not written into the law yet.
ところが、やはりこの高知放送事件をきっかけに、その後を出されている判例でも、やはり同じような論理で、結論が出てきました。
However, in subsequent court cases, a similar reasoning was used in verdicts.
で、そこでですね、今では、労働契約法第16条というところに、この解雇権乱用法理っていうものが、明文化されています。
Yeah. And now the principle of 解雇権乱用法理, the principle of the abuse of the right to dismiss, is written explicitly in Article 16 of Labor Contract Act. And this is just me, but this often happens in Japan where precedent leads to law. So many precedents with similar reasoning often later is codified in the actual law.
はい。皆さんのはこの判決のね、結論当たってたでしょうか？
So I'm wondering if everyone guessed correctly that the court ruled against the dismissal.
私大学でも労働法の授業を持ってるんですけれども、学生からこんな質問来るんですね。
I teach labor law at a university, and students often ask this question.
学生がね、じゃあ私これから会社に就職して2回寝坊してもクビにはなりませんねって聞かれるんです。
So students say, so if I go work at a company and I oversleep twice, I won't be fired?
いや、それは違いますよ。
No, don't think like that.
さっきもね、説明しましたように、そこの部分だけを取り出すのではなく、いわゆる本当に総合的勘案っていうことと、あと他の労働者との公平性っていうのはすごく重視されるんですね。
Yeah, so don't take out one part of the case and just focus on that. You have to look at the entire case and the entire circumstances, as well as how the employer treats other employees.
で、この原告の場合もね、20年働いていて、それ以外にはミスをしたことがなく、真面目に勤務してたっていうところもかなり重くね、評価されているので、そういうところはね、勘違いがないようにお願いします。
And be careful. The Supreme Court also looked at the fact that the employee had worked was a good employee for 20 years and took that into consideration in the Supreme Court's judgment.
で、そしてね、あと、解雇権乱用法理の判断基準っていうのも、私たちの社会の認識によって、裁判所が今後判断を変えてくる可能性もあると思うんですね。
And also, as social values change, it's possible that even with the exact same case, courts may start to change how they view these cases. So be very careful not to misunderstand in these cases.
例えば私の大学の学生の中には、3割ぐらいの学生はね、この判決は甘いっていうふうに言う学生がいるんですね。
Yeah, 何人ぐらい
？3割ぐらい。
About 30% of my students at university say that they think the verdict was too lenient to the worker.
で、2回もね、寝坊しているっていうのは、やっぱりアナウンサーとしてはもう失格だって結構厳しい声もあるんですね。
Yeah, so some of the students think that he should not be an announcer. He's not qualified to be an announcer if he oversleeps his own show twice.
なので、裁判所って意外と私たちのこの時代の感覚、一般人の感覚って意外と気にしているので、もしね、そういうふうにいや、これは甘いっていう人が大半になってきたときに判断が変わる可能性っていうのはあると思ってます。
Yes, so, courts are surprisingly sensitive to the mores of the day. So if the majority start to think that the Kochi broadcasting case, the judge was too lenient, then it's possible that judges will become more and more, they will more and more take that position.
はい、ということです。はい、じゃあ、高知放送事件はここで終わります。もう少しスピードアップした方がいいかな。ね、はい、じゃあ、2つ目ですけれども、これはね、結構注目すべき新しい判決になります。
Okay, one more time.
2つ目、これから紹介する判例は、 公示放送と違って、1年前に出された新しい判例になります。
So unlike the case I just introduced, this next case is not an old case, it's a very recent case.
でちなみにこの判例に関して細かいことはですね、新月ニュースエージェンシーというところのブレッド&ローズっていうコラムに今週書きましたので、関心がある人はそちらもお読みください。
Also, I wrote a story about this case in Shingetsu News this week. So if you'd like to get more information about it, please check out my article in my Bread and Roses column in Shingetsu News.
So it suddenly stopped.
Live stream stopped?
Yeah. Can't do anything.
Live stream でいいかどうなってるか。Froze しちゃった。
映像は止まってる。
Is it live stream 問題 or problem or Zoom 問題?
Probably Zoom.
Is it, oh, maybe it's not our computer, it's Zoom? So we're going to have to send another link. Zoom is unreliable, maybe.
今日ちょっとあれですね。調子が悪いですね。
So right now they can't hear us.
なんかでもコメントが
They can?
seems okay to me って書いて
Who said that?
てジェフ・ムーアス。
Can you hear us?
フローズ。The live stream of Luis and Hifumi froze, but the slides were okay.
Okay, can you hear us?
Oh, we can hear.
Should we continue then? Maybe we just continue?
Yeah.
We can hear. Oh,
Okay,
聞こえる。
so
じゃあ続きますか
with that, we'll just continue with that slide, and there's like 2 more slides, so let's just continue.
Okay, okay. はい。
If the slides come back, just do it, and then,
はい、じゃあ。
okay, so let's just do it,
続け
yeah.
ますね。
Okay, based on responses from our viewers, we understand that the video is frozen, but you can hear our voices, so we will continue. Okay,
OK。ですね、これは一言で言うと、俳優は労働者かっていう争点ですね。
Yeah. Now, the point of contention in this case that I'm about to introduce is an actor an employee? Is an actor a 労働者?
はい、でこれもね、さっきルイスが結構細かく説明してました、労働者性の判断っていうのはこうね、全部で8個だっけ、8個の、ファクターに照らし合わせながらね、実態として、労働者かどうかということを判断していきます。
Yes, so this is, as Louis explained, the 8 factors in determining whether someone is a 労働者 employee or not. This relates very much to that.
はい。で、まずね、ちょっと日本の劇団に所属している、なんていうのかな、こう、超有名じゃないけれども、活動しているような俳優さんはですね、基本的に労働者とはほとんど見なされてないです。
Yeah. Now, first of all, I should say that for most actors in troupes and studios that are not extremely famous actors, almost none of them are treated or considered employees or 労働者. And this, I'm just talking about the reality, not what the courts say, but this is, they're considered to be not employees.
で特にね、日本におけるそういうこう俳優さんのキャリアというか俳優さんの位置づけっていうのはちょっと特殊だと思うんですね。
Yeah, and I think the profession of acting has a special status in Japan.
一言で言うとすごく前近代的なちょっと徒弟制度みたいななんていうのかな、こう本当に自分が一人前になって成功していくまでっていうのはお金とかもらわないでもう一生懸命修行するっていうそういう環境がほとんどなんですね。
Yeah, the entire environment is based on this idea of master and apprentice. This idea that you have to really struggle and have no money and suffer for your art until you become successful.
はい。で、あとその特徴としてはね、 舞台に立って自分は俳優として演技したいっていうふうに思ってはいるんだけれども、でもその長い時間の間は、その舞台に立つよりもむしろ裏方の仕事、大道具とかね、音響とか照明とかそういうものも一生懸命そういう仕事もやるっていうのがまあ半ば当たり前になってる、そういう世界ですね。
Yeah, and so it's a world in which it's just assumed that even though you want to act on stage, before you do that, you have to do all kinds of other work backstage, dealing with sets and props and all that other kind of stage managerial and tech crew work.
ですので、多くの人は劇団に入れれば、そのお金をもらえるって多分思ってないと思うんですね。
Most people who join like an acting troupe or a theater troupe don't even expect to get any money from it.
舞台に立たせてもらえるだけでありがたいっていう、そういうふうに思って入ってくる人が多いと思います。
Most of them are thankful even for the chance to walk out on stage.
で、そうですね。ですので、そういうでも俳優を目指して劇団に入る人っていうのは、10年もしくは20年ぐらいはもうただで舞台に立ちながらアルバイトをいっぱい掛け持ちとかしてギリギリの生活を送ってるっていう人が多いと思います。
Yeah, and so often they work 10, maybe even 20 years without any money from the work, and they have to do other jobs just to get by.
で、まあそういう世界なんですね。で、そういう世界の中に、まあ、今回のこの裁判所の判例っていうのは、なんか本当にちょっと穴を開けたというか、その今まで当たり前だと思ってた世界に、なんていうかな、労働法っていう風が入った初めての判例かなと思いますね。
So the verdict I'm about to explain basically broke all that open. It punched a huge hole in this entire world that was based on all those assumptions.
じゃあちょっとこの事件の概要を簡単に説明し
So
ま
let
す。
me explain this case, give you a brief outline.
はい、原告は男性の俳優目指していた人です。
So the plaintiff is an aspiring actor.
で、20歳代の時にこのエアースタジオという劇団に入団しました。
And in his 20s, he joined a theater troupe run by Air Studio Company.
で、これ契約は入団契約なので雇用契約ではありません。
So the contract was not called an employment contract, it was called a contract for entering the troupe.
で、劇
Like
団
a troupe admission contract, I guess. Yeah.
はい。で、劇団に入ってから最初の5年間は、まあ、全くのタダでした。お金が0円でした。
So the first 5 years, he got zero pay of any kind, yeah.
で、ただですね、このエアースタジオがカフェをね、運営していたんですね。
And Air Studio, I'm sorry, yeah, Air Studio also ran a cafe.
で、彼はですね、このカフェで空いてる時間にアルバイトをして、そこでまあバイト代を稼いで。
And in his free time, he worked at that cafe, and they did pay for that work. And that's through that part-time work, he basically managed to make a living, enough of a living.
そうですね。で、エアースタジオ自体もそのカフェに関してはこれはアルバイトっていうことは認めて労働法の適用がある、まあ、バイト代をちゃんと労働法にのっとって、賃金払ってたということですね。
So Air Studio never denied the fact that the work at the cafe was 労働 and that for that work he was 労働者。
で、ここは争いありません。
There's no dispute about that.
で、ですね、それ以外に、まあ、本来の活動、舞台に立って演技をするということと、あと裏方の仕事ですね。
So other than the cafe work, there were two types of work that he did. One was actually acting and performing on stage. The other was all this backstage work, set, prop, tech crew stuff.
で、こっちに関しては最初の5年間は0円だったということですね。
And for that work, the company refused to pay anything.
で、入団してから5年後にですね、エアースタジオの方が、まあ、ちょっと生活大変そうだからっていうことで、支援金という名目で1ヶ月に6万円を払うようになりました。
So after the 5 years, Air Studio, in effect, the way they described it was like taking pity on him, and they started to pay him 60,000 yen a month aid, not wages, but aid. Yeah.
で、これはさっ きのカフェのバイト代とは別個っていうことですね。
And this was separate from what they paid for his work at the cafe.
で、彼はですね、そういう形でカフェでバイトをしながら、であとはその月に6万円を途中からもらって、で裏方とそれから舞台に立つという活動をやってました。
So he did all that work at the cafe and performing on stage and also the backstage work, receiving the money for the cafe and for the 60,000 yen a month in aid.
で彼曰くですね、こういう生活してて、ほぼ365日休日がない状態だっていうことだったんです
And
ね。
according to him, he basically had no breaks and worked 365 days a year.
で結局ですね、もうこういう状況の中で、先が見えないっていうことと、あと経済的にもすごくもうギリギリになってしまった、そして体も壊してしまった、満足に食事をとるっていう余裕もなかったっていうことで、もう劇団を退団することになりました。
And because he was having such financial problems that he couldn't even eat properly, and because he saw no future, he decided to leave the troupe.
はい、で彼はですね、さっき言ったように、でも劇団に入ってる人って同じような生活してるからこんなもんだっていうふうに思ってたそうなんですね。
He thought that, well, this is just what life in a theater troupe is like. He had thought, yeah.
でも、辞めた後で、いろいろと考えてみると、裏方の仕事とかはもう本当に指揮命令を受けて、もうどこそこに行ってこれをやれっていうふうに明確に指示されて、でもうやらざるを得ないっていう状況にあったにもかかわらず、その、労働法の適用がなくって月に6万しかもらってないっていうのはやっぱりおかしいんじゃないかってだんだん思ってきたっていうんですね。
And so he started to feel kind of indignant that it was not right that he was actually getting orders for all the backstage work and working really hard and clearly receiving all these work orders that he had to comply with, and yet labor law did not apply.
はい、で会社はですね、エアスタジオ側は裁判の中で、いや彼が言ってることは全くおかしいと。でもともとその劇団に入って俳優を目指すっていうのはその本人がね望んでここに入ってきたことであって、で最初の入団契約っていうのも雇用契約ではないっていうことも納得してね入ってきているので、今更その労働法の適用を求めるのおかしいっていうふうに会社は言ってました。
But management rejected his arguments and said that he chose to join this troupe voluntarily of his own will, and that after all these years, now for him to suddenly claim that labor law applies is ridiculous.
はい、でですね、これ実はまず東京地裁で第一審の判決が出てます。
So the Tokyo District Court ruled.
で第一審ではですね、その舞台に立つ俳優としての業務は労働者性ないって言って、でも裏方の仕事に関しては労働者性があるって言って、裏方に関しての未払い賃金の支払いを命じました。
The Tokyo District Court ruled that his work as an actor does not correspond to Rodo, so he was not a Rodosho for that. But his work backstage was Rodo, and they ordered the company to pay his wages for all that work.
で、ここでですね、原告被告双方控訴するんですね。
Now there was a mixed verdict, so both sides appealed.
で、原告側は、いや、俳優としての仕事も労働者性が認められるはずだというふうに主張しました。
So the plaintiff appealed, arguing that even his work on stage was Rodo and that he should be paid wages for it.
で、会社側の方はですね、いや、裏方業務も労働者性は認められるはずがないっていうふうに主張しました。
Whereas the company, Air Studio, appealed, claiming that even the backstage work was not Rodo and that he should not be paid.
会社の主張っていうのはあくまでもその劇団に入って活動するっていうのは労働じゃない。これは本人がね、その演技をやりたい、劇団に入って活動したいっていう自主的かつ任意的なものなので、そこに労働法が入り込むのはおかしいっていう劇団の主張ですね。
So the company said that first, just joining the troupe, none of that is Rodo, none of that is work for which wages should be paid. That is something voluntary. And it's simply something that someone does voluntarily and it's not Rodo.
はい、そこで第2審ですね、東京高裁の判決が去年出たんですけど、どういうジャッジを下したと思いますか？ジャッジ。
Okay, so I wonder what our viewers think about this case and what they think about that.
どうでしょう。で、
should we speak or discuss it? Or? いいよ。
で、判決はですね、判決は、演技の方も、それから裏方の方も、両方労働者性があるっていう判決を下しました。
And the verdict of the High Court was that both types of work were rodo. In other words, his backstage work and his acting on stage were both rodo and should be paid as wages. And they ordered the company to pay those wages.
ということはですね、労働法の適用があるので、その月に6万円の支援金っていうのは、最低賃金を大幅に下回るってことになるので、差額の賃金を払いなさいという判決が出ました。
Yeah. So the High Court ordered them to, the High Court noted that the 60,000 yen he got in aid was way below minimum wage. And so they ordered the company to pay the difference between that 60,000 yen and what would be minimum wage.
で、先ほどのルイスのね、労働者性判断のいろんな条件がありましたけれども、裁判所はですね、まずこの劇団に入って活動している人は、原告は諾否の自由が実質的にはないっていう判断なんですね。
And so what the courts determined was that he didn't really have the freedom to say yes or no to work to work orders that he was given.
で、実はこれはですね、例えば、俳優として舞台に出るときだったら、一応ね、劇団の方から今度こういう劇があるんだけれども、あなた出演しますかって一応聞かれるそうなんですね。
So, of course, when they're doing a new play and they want him to perform, they ask him, do you want to take this role?
で、なので、一応、それノーって答える自由もあるにはあるんだけれども、ただ裁判所は実態としてそこで劇団員が自分で選択できる自由っていうのはなかったっていうふうに言ってるんですね。
But of course, he can say no technically and still remain the truth, but the court judged that, he doesn't choose what roles he takes, and of course, he joined the troupe with the goal of becoming an actor. So.
はい。で、あと裏方の業務に関して言えば、やはり裏方の業務もその諾否の自由があるとは言っていても、やっぱり裏方の仕事をたくさん引き受けていっぱい貢献してる人の方が舞台にたくさん立てるっていう気持ちが劇団員にはあるので、それもやっぱり諾否の自由は実質的にはなかった。
Yeah, and so even though the company claimed that they had the right to refuse backstage work, in reality, those who did the most backstage work were the ones who got roles to perform on stage.
はい。で、あと例えば指揮命令下に置かれているかどうかっていう要件に関しても実際にもうこの舞台は何年何月何日から何日までどこそこの劇場でやるっていうのはもう1年間スケジュールが決まっているわけなので指揮命令下に置かれているし、あと場所と時間の指定っていうものもすごく厳格にあったっていうことも認めてますね。
And the court also judged that in terms of being under the command of the company, that like the timing of the plays were all decided and the place of his work was all decided, and so that he was under their command.
で、結論としてそういうふうになりました。で、これはですね、日本のその劇団業界にものすごい大きな波紋を広げたんですね。
And this really threw the entire industry for a loop. This verdict really surprised the industry.
で、やっぱり何人かのその劇団の代表の人とかは裁判所っていうのは日本の劇団の文化を壊したいのかと、もうこんなことしてたら日本の劇団は小さな劇団全部潰れてしまうっていう、そこまで結構激しい言葉で批判してる人がいます。
And some companies criticize the verdict, saying that the court is trying to destroy the industry and that small theater troupes won't be able to survive in the wake of this ruling.
ただですね、これもちょっと私の学生の話を聞くと、私の学生はほぼ 100% これは当たり前の判決だよねって言うんですね。
But most of my students think that the verdict was totally understandable.
でやっぱりここまで場所的、時間的拘束を受けて、自分の自由なく自分の時間を捧げて、お仕事してるっていうことであるならば、他のアルバイトと何ら変わりはないので、この判決は妥当だっていう人がほぼ 100% ですね。
Nearly every single one of my students said that the verdict was appropriate because the guy's the time and place was all decided, and he had to devote his work during those times and at that place.
なのでやっぱり劇団の常識と、それから一般社会の常識っていうものがやっぱりかなりかけ離れていたんだろうと思うし、この判決出たことでやはりノーマルな働き方っていうのをやっぱり劇団の人も考えていかなきゃいけないんじゃないかなと思います。
So I think that what was common sense in the theater industry was very different from the rest of society, and so I think the theater industry must start to rethink how they consider this kind of work.
はい。ということで、じゃあ最後の判例ですね。
Okay, so this is the last verdict now?
法営事件と言います。
This is the Hoei case.
1997年の判決ですね。
This is 1997 verdict.
これは今2つの判例と比べるとあんまり有名じゃない、ちょっとマニアックな判例ですね。
This is a slightly less famous verdict, and this is for people who are really kind of a nerd about verdicts.
ただですね、これを聞いてくれている方が多分英語圏の方が多いと思うので、英語圏の方にとっては重要かなということで紹介します。
I think many Anglophones are viewing us, and this is a very important case for Anglophones.
ですね、これはさっきルイスから説明もあったんですけれども、その退職の自由とか、退職の意思とか、そういったものがそうでですね。
And the point of contention here is what Louis spoke about, the freedom to resign a job, 退職の自由。
でですね、原告はカナダ人の男性ですね。
The plaintiff is a Canadian man.
で、この原告がですね、4日ぐらいちょっと無断欠勤をしてしまったそうなんですね。
And he didn't show up for work 4 days in a row.
で、この無断欠勤に対して、その上司がこんなことを繰り返してたらいずれ解雇になるぞというふうに言いました。
And the employer said, if this continues, it will eventually going to have to fire you.
で、その後ですね、別の上司が出てきて、ちょっと反省する意味も込めて、配点しますと。で、配点に従わない場合は、もうあなたから退職してもらうしかないですねっていうふうに言いました。
And so another manager came and said, okay, we're going to transfer you somewhere else. And if you don't accept the transfer, then we want you to resign.
いわゆるルイスがさっき言ってた退職勧奨。
So this is 退職勧奨. In other words, pressuring someone to resign.
で、じゃあ配点に従わない場合はもう自ら退職していただくしかないですよねっていう。
And they said, you'll have to resign if you don't agree to the transfer.
で、その言葉に対してこの原告がですね、それはグッドアイデアだと言ったと。
And the Canadian plaintiff said, that's a good idea.
で、そこでですね、会社が、
In English, he said in English.
で、それで上司がですね、本人もグッドアイデアだって言ってるから、じゃあこれ退職をするっていうことですねっていうことで、